Is that the motion be agreed to?
Mr. Speaker.
I call the honourable member Nikki Wagner.
Thank you very much, Mr. Speaker, and I'm very pleased to be speaking to this Tasman District Council Validation and Recovery of Certain Rates Bill at its third reading. And I'd really like to commend the work of Damien O'Connor, who's the sponsor of this bill, because he makes a very good point. This bill came to the House because of the disputes between the ratepayers and the Tasman District Council. And those things could have been dealt with earlier if they had been more sympathetic to each party. And we did try in the Select Committee. We actually had the Council and the ratepayers to the Select Committee on 2 occasions, and we tried to mediate something because, of course, again, as Damien O'Connor has said, Parliament doesn't like validating legislation. It doesn't like anything that looks backwards. We like to be positive and look forwards. And we have had a rash of validation legislation recently. Unfortunately, they do come before us. I think really in this case it was errors. There was no malicious intent that led to this situation. And in the long term, Parliament has to pass this legislation for the public good. Now, what this bill actually does is validate the rates that were set by the Tasman District Council in the period of 2003 and 4 to 2008 and 9, and that was a while ago. And that was because during that time the Council did not follow the correct procedure in setting rates. The bill also validates the rates and penalties paid over that period and authorises the Council to recover any unpaid rates. And furthermore, it ratifies the Tarter Beach and Liger Bay stormwater rate, and that is really the most controversial part of this bill. In 2003-4 to 2008-9, the Tasman District Council passed rates attached to its annual plan, rather than ratifying each rate individually, and that set the rates before the Council had adopted the annual plan. And this was a breach of the Local Government Rating Act in 2002. There was also the debate over the consultation and the documentation pertaining to the Tarter Beach and Liger Bay stormwater rate. Now, the Rating Act does provide an avenue for councils to amend incorrectly set rates, which is this case, but the window for that time had passed. So unless you do it immediately, you have to go through validating legislation. So this validation was required to allow the Council to recover unpaid rates and penalties, and without the validation, the Council remained vulnerable to legal challenges from ratepayers over incorrectly set rates. Now, as I've said, the Tarter Beach Liger Bay stormwater rate was probably the most controversial area in this bill, and it boiled down to a debate between the ratepayers and the Council. There was a debate over how the ratepayers should have been rated, but that wasn't the legal situation that led to this bill. Basically, what happened was there was a mistake in the documentation, and the process was not followed correctly. And when the ratepayers complained, they did not get a sympathetic hearing from the Council, and that escalated. It escalated till they went to the Ombudsman and actually dealt with the Ombudsman, and the Ombudsman came back and said, yes, the Council had made a mistake, and then they had to go through all their documentation to the past, and all these other areas were again came to light. So it was because of the ratepayers and because of this dispute between the ratepayers and the Council that this situation came to pass. Now, in this legislation, Clause 9 was the clause that dealt with this rate, and the Select Committee was very sympathetic to the proposals to perhaps delete Clause 9, simply because that was what uncovered all the errors. But we found that it was outside the scope of the bill and that it was impossible for us to do. And that's why we persevered with trying to come to some arrangement between the Council and the ratepayers. I need this is one of the key issues that we need to think about in terms of this type of legislation, and I echo the concern of Damien O'Connor about councils working more closely with their ratepayers. When you really think about it, councils and ratepayers have the same outcomes for themselves. They want to have the same thing. We need good infrastructure, we need good efficient services, and that's to underpin a quality of lifestyle in their area. And ratepayers and councils should be working together because, after all, they are mostly reasonable, sensible people, and together they can get a better outcome. The Select Committee worked hard on this bill. As I say, we've been looking at validation legislation, and this was another case that came through. We reflected on the fact that councils do need to be very careful with their documentation, and that we think that going forward, legislation needs to be simpler so it can be understood, and National is very keen to make local government more efficient, more responsive and better focused. I think the other thing that's important for this bill is it will highlight to other councils how important it is that they get their documentation correct. When you look at the errors that were made in this case, I'm sure there are other councils throughout New Zealand who've probably made similar errors, and they need to be very careful about how they do that. And I have also heard that there are more validation bills to come to the House. So finally, I would like to thank Damien O'Connor for his work. I think this is a very good example of a council that perhaps should have been more careful with its documentation, but also should have been more careful with its relationship with its ratepayers, and in the end this validation legislation had to be passed so that they could collect the rates and penalties during that time, and also so they were not vulnerable to legislation in the future. So I support this bill to the House.
I call the Honourable Member Sua William Sio. Tolo Falava.
Talo Falava, Mr. Speaker. All that needs to be